I'd like to introduce our two speakers, Micah Schwartz and Amanda Weaver. Micah is a commercial litigator. He focuses on employment, workplace safety, and education cases. He represents clients in state and federal courts at the trial and appellate levels and counsels clients on sensitive matters to keep them from maturing into litigation. Amanda Weaver advises employers on compliance with various state and federal employment laws. She helps clients maintain compliance with anti-discrimination laws such as the Americans with Disabilities Act, Fair Labor Standards Act, and Title VII, and similar state anti-discrimination and accommodations laws, including advising clients on compliance with discrimination laws that pertain to the rapidly evolving area of gender identity and transgender transitioning employees. Micah, I'll turn it to you to kick us off.
Thank you, Farhad, and good morning to everybody. Again, my name is Micah Schwartz. I'm an employment attorney in our Charlottesville office, and I'm joined by my colleague, Amanda Weaver, another employment attorney in our Richmond office. The title of our presentation this morning is Employers' Rights to Limit Employee Competition and Disparagement and Demand Settlement Confidentiality. That's a mouthful, so why don't I break that down. We're going to be talking about different types of agreements that we have with employees, primarily at the outset of the relationship, the employment agreement, and then when the relationship comes to an end, the severance agreement or the separation agreement. And within those agreements, we're going to be talking about a couple issues in particular. First of all, with the employment agreements, we want to talk about non-compete terms in particular, because you all may have heard about them in the news recently. There is a federal rule, a proposed rule, which imperils these non-compete agreements. Amanda's going to talk about that soon. Many, I think that those terms are already dead on arrival. The rumors of their demise are greatly exaggerated. They're still legal at the federal level, but they're imperiled, and Amanda's going to talk more about that soon. And then during the second half of the presentation, I'm going to talk about agreements in the second half of the relationship with employees, again, separation agreements, and in particular, confidentiality terms, meaning confidentiality about the separation agreement and if there are severance payments in the agreement, and then also non-disparagement terms. Those are popular terms to include in severance agreements. They're on life support now because of a recent decision by the National Labor Relations Board. I'll get to that later. We're also going to cover a couple of miscellaneous issues involved in separation and employment agreements, covering some questions that we often get from employers. But if we can move to the next slide, and I'm going to hand it over at this point to Amanda. Amanda, do you want to take it from here?
Sure. Thanks, Micah, and good morning. I'm Amanda Weaver. As Micah said, our first section this morning is going to pertain to employee non-competes and the myths versus the realities. Are we supposed to have a polling question before? Yeah. So our first polling question, and Micah may have helped you cheat a little bit, but true or false, the FTC has banned non-competes at the federal level. Take a moment, submit your answer. Just a reminder, if you've requested CLE credit, responding to each poll to verify your attendance is required. So please make sure you submit answers to each of the polling questions throughout the program. It's a couple minutes left, so make sure you've submitted your answer. Okay. It's still a bit of a trick question, even if the answer is hiding right behind the polling question. The truth is the FTC has in fact tried to ban non-competes essentially at the federal level, but that ban is not yet in effect. So I think the technically correct answer is false. They have not succeeded yet in their goal of banning non-competes at the federal level, but certainly that is what they are currently trying to do. But yeah, so contrary to popular belief, nothing has changed at the federal level as of today. That being said, the popular belief that it has, or that non-competes have been banned in their entirety, is based in reality. And that's because the FTC earlier this year did issue a notice of proposed rulemaking for a non-compete rule that would in fact limit or prohibit employers from essentially ever having non-competes with employees in the way that they have to date. So this proposed rule from the FTC, it arises out of President Biden's 2021 executive order on promoting competition in the American economy. In that executive order, President Biden directed the chair of the FTC to consider a rule like this one that would, as President Biden put it, be an exercise of the FTC's statutory rulemaking authority under the Federal Trade Commission Act to curtail the unfair use of non-compete clauses or other clauses or agreements that may unfairly limit worker mobility. Now, does the FTC Act actually say that? Not specifically, and that's one of the issues that I think we'll continue to see battled out with this proposed rule. But in response to that 2021 executive order, the FTC issued a policy statement in November of last year in which it affirmed or confirmed that its interpretation of the FTC Act is that it encompasses various types of unfair conduct that tend to negatively affect competitive conditions, presumably including employer use of non-compete clauses. And this is a broadening of the way that the FTC Act has, at least historically, been interpreted and applied by the FTC. I mean, up until now, the focus has typically been on more intentional conduct that is aimed at anti-competitive harm or is intended to have anti-competitive harm, like collusion and things like that, as opposed to more policy level decisions and actions by employers, like the use of non-competes, which have been pretty ubiquitous. So the FTC's reasoning behind moving towards addressing non-competes is that in its belief, the non-compete agreement or use of non-competes with employees results in a decline in job mobility, meaning in their view, if non-competes are ubiquitous, then employers are less inclined to offer employment on competitive terms to employees that may work for a competitor. They are, less inclined to try to entice away those employees with better wages, better benefits, or other terms and conditions of employment, which of course we want to try to encourage employers to do and encourage that sort of competition. So that's what's driving the rulemaking here. But as we'll talk about, and we can go on to the next slide, we have not actually changed the law at this time. So what does the proposed rule say? The proposed rule says that it is an unfair method of competition for an employer to, 1, enter into, or 2, attempt to enter into, or 3, maintain, meaning still have, or 4, represent that an employee has a non-compete clause. So that covers a broad range of conduct, meaning, that an employer is not allowed to present a non-compete clause to an employee to sign, to actually enter a non-compete clause with an employee, to keep in place a non-compete clause that it has previously entered with an employee, or even to try to deter or dissuade an employee from competing by representing that there is some sort of prohibition that doesn't exist. And what is a non-compete clause under the proposed rule? As currently defined, it would be a contractual term between an employer and a worker that prevents the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. We can go to the next slide. I think that's a little early. Thanks. So obviously that's a pretty broad definition. If employees are not allowed any restriction that would purport, and we're only talking about post-employment, which is an important distinction, but any employee restriction that would prohibit an employee after they leave employment with an employer from becoming employed with any person or operating a business is going to be a prohibited non-compete clause under the proposed rule. There are important exceptions, even under as broad as it is. There are some exceptions that are already worked into the proposed rule. The first being non-competes that are entered in the context of a sale of a business. And that's not a surprise. Those have always been treated differently and with a lower level of scrutiny by courts, given that if you've got one business selling a company to another, you have sophisticated parties, represented parties with equal bargaining power and sort of stronger interests in protecting against competition. And so those are not part of this rule. This rule is really focused on prohibitions on workers and not sellers of a business. That said, there are some exceptions that we would expect to see that are not addressed in the proposed rule as it was proposed. So, for example, it is silent on whether customer non-solicitation clauses fall within the purview of the rule or whether they are going to be treated separately or whether they're still going to be allowable at all if this rule becomes final. And given the broad definition of non-compete that was included in the rule, one could argue that it would encompass at least some types of customer non-solicitation provisions. And when I'm talking about a customer non-solicitation provision, I mean a provision that says you employee cannot leave our employment and then go and offer the same services to a customer of ours, which is distinct from a non-compete. And often, at least on this, as we've seen these non-compete laws come out at the state level, often they are very explicit that they exclude customer non-solicitation clauses because they've historically been treated with a little less scrutiny than pure non-competes that, as understood colloquially, means restrictions on just working for a competitor, full stop, whether you're taking employees or taking customers with you or taking trade secrets or not. So that's an open question to the extent that the part of the definition that encompasses accepting employment with a person might be implicated by a customer non-solicit. If you have a non-solicit that prohibits employment with a customer, then presumably that would fall under the definition as it's currently drafted. But that said, it's not necessarily in line with the intent of the rule, which is to curtail the sort of anti-competitive effect between competitors of having non-competes in place, meaning, if I'm restricting my employees from going to a competitor, then I'm discouraging that competitor from trying to lure my employees away with better terms. That might not necessarily apply so much in the context of customers. So I suspect that's something that we would, or at least hope that we would see a little bit more clarity around as this rule becomes finalized. It's also noteworthy that the rule as it's drafted now would propose contractual terms that function like a non-compete, even if they're not called a non-compete, and that's probably not a surprise. Not that any of our clients would ever do it, but I have certainly seen agreements where people try to get a little clever and achieve the same result as a non-compete would achieve. For example, if an employee has some sort of financial penalty for competing, it's maybe not a contractual obligation not to compete, but some sort of repayment obligation is triggered if they compete within a certain amount of time. I think the rule is trying to encompass those sorts of provisions as well to achieve the result that it's trying to achieve. And we can go on to the next slide. So what happens to current agreements if you're an employer that has non-competes with any employees and this rule takes effect? What happens then? So as it's drafted now, the proposed rule would require employees to affirmatively rescind any non-compete clauses currently in effect, and to do so within 180 days. So that would require not only terminating at least the non-compete portion of a violative agreement, but also providing written notice to the employee that that provision or that agreement has been rescinded. And there is one good thing, which is that it's treated as a safe harbor under the rule as it's currently drafted. If an employee does this, if they have a non-compete or something that functions like a non-compete, and they rescind it within 180 days of the rule becoming final, and they give the required notice to the employee that it's been rescinded, then they would fall within the safe harbor provision, and there would be no liability for the fact that that non-compete once existed, but now no longer does. Next slide. So, as you can imagine, people have had a lot to say about this proposed rule. Again, it was the proposed rulemaking, or the notice of proposed rulemaking, came out in January of 2023. And initially comments were due by March. And the agency ended up having to extend that into April due to the volume of comments that were being received. It was around 27,000 comments received in response to this proposed rule. And it did get support. I mean, there were support from legislators and from various interest groups, but also, as you can imagine, a lot of pushback, including from the U.S. Chamber of Commerce, with concerns about how restrictive the rule would be as it's drafted, as well as the harm it could cause to employers who are essentially unable, as this rule is drafted, to protect against any sort of competitive employment for a period of time after an employee leaves, potentially even protect against the use of their trade secrets. And so we can expect that, well, I guess given the volume of comments that were received, which shouldn't have been a surprise to the agency, and I'm sure it wasn't, they decided to take a beat. They are not expected to vote on this rule until 2024. I'm not even sure when. But that's sort of the expectation, that it will be pushed into the next calendar year. And I think we can expect that any final rule, if finalized, is likely to scale back some of the scope of this in response to the comments that were received. And if it does take effect, I think we can also expect that any final rule is going to be challenged on the basis of whether the FTC does in fact have authority under the FTC Act in the first place to institute this sort of rulemaking that delves into non-compete clauses, which is again sort of a broadening and expansion of what how the authority has been interpreted to date. The takeaways here being that, certainly the current administration and the trend in the federal government is towards significantly, if not entirely, limiting employee non-competes, which is in line with state law trends that we've seen over the course of the past 5 to 10 years. We've seen many states enact restrictions or outright bans on non-competes in the employment context. But that being said, there are a lot of hurdles to get to any sort of enforceable final rule, and we'll just have to see how that all plays out going into next year and perhaps beyond. You can go to the next slide. This is when we should do the polling question. Right, next polling question, and again, a reminder, if you're applying for credit, you need to respond to each one of these polling questions throughout the program. But which of the following most accurately describes the current status of non-competes in Virginia? 1, non-competes are allowable for any employee so long as they are narrowly tailored and reasonable in accordance with Virginia common law. 2, non-competes are only allowable for certain categories of employee and must otherwise meet reasonableness standards under common law. Or 3, non-competes between employees and employers are not enforceable. Okay, we've got close to an even split between answers 1 and 2, and you know, it's not entirely wrong. The correct answer is 2. Non-competes are only allowable for certain categories of employees and then are otherwise subject to common law reasonableness requirements. But answer number 1 was what was the law up until a couple years ago in Virginia. So just like many other states, it's rapidly evolving in Virginia as well. So just like under federal law for now, non-competes are allowed in Virginia. They are not per se unenforceable. They're still alive. They're not even on life support. They're still being used. However, since 2020, Virginia has had a non-compete statute that applies to certain non-competes entered with certain categories of employees, not all non-competes with all employees. And we'll talk about that in the next slide. But regardless of whether a non-compete falls under the Virginia statute, non-competes in Virginia are still going to be analyzed by courts on based on a reasonableness standard. So courts are going to look at whether a non-compete is reasonable in geographic scope, reasonable in duration, and reasonable in functional scope to decide whether it's going to enforce an employee non-compete. And it's a totality of the circumstances type of review. For example, in geographical scope, the geography in which an employee is restricted from competing needs to be limited to the area where the employer actually does business or draws customers. And in some cases, when the employer's business is global, or you know, at least national or global, it may be that the employee themselves does not interact with customers or have access to business information on a global scale. And so their non-compete must be limited to the area where they actually have goodwill with customers or involved in the business. It also has to be reasonable in duration. There are older Virginia cases that have enforced non-competes that are longer than 2 years in duration, but they are now quite old. In fact, I haven't even seen a 2-year restriction in some time. And so candidly, we typically push for limiting non-compete, post-employment non-compete restrictions to being no more than 12 or 18 months, unless we're talking about the founder or the CEO of the company. That tends to be enough to protect the most dangerous time after an employee leaves, and signals to a court or anybody that's reviewing the reasonableness of the restriction that you've been thoughtful about it and you haven't shot for the moon. And then finally, it's got to be reasonable in functional scope. What is the employee restricted from doing? A prohibition against going to work for a competitor, full stop, is not going to be enforceable in Virginia because it violates the so-called janitor rule, meaning an employee's restriction against working for a competitor needs to be limited to the types of duties and services that the employee performed for you. So we always want to draft those thoughtfully as well, to make sure that the employee is only being restricted from doing something that it did for you, so that their restriction is tied to the types of business information and the types of customers that they had access to when they worked for you. And it's important to note that in Virginia, courts do not blue pencil. They don't modify overbroad restrictive covenants. That's not something that's ever been specifically addressed by the courts, but they just don't do it, meaning it is absolutely an employer's best interest to draft these things as narrowly as they can possibly be, to avoid a situation when a court sees it and says, well, this part's too broad, so I'm just going to strike the whole thing. I'm not going to fix it for you. We can go to the next slide. We have Virginia's non-compete statute, which again came out in 2020. And under this statute, employers are prohibited from entering into, enforcing, or threatening to enforce a non-compete agreement with any low-wage employee, which is a term of art that's defined in the statute. It defines what a non-compete is. It defines what a low-wage employee is. A lot of other things it doesn't really define. It's an extremely ambiguous statute that's a little bit difficult to grapple with as an employer, but we'll talk about that. And this statute applies to contracts entered on or after July 1st, 2020. So just the fact, unlike the proposed federal rule, there's not an obligation to affirmatively rescind a non-compete that with a low-wage employee that existed before that date. But there is a restriction against trying to enforce it. So it's not a violation of the law just to have that agreement floating out there in the world. But if you were to try to go after a low-wage employee under a non-compete in Virginia, even if it was signed before 2020, that would be a violation of the statute. We can go to the next slide. All right, so what is a low-wage employee? A low-wage employee is, and this is a long definition, but what it comes down to is an employee whose average weekly wage is more than the median weekly wage in the Commonwealth of Virginia. And, you know, it provides a way to determine that either based on the last 52 weeks of employment, or if less than 52 weeks of employment, you know, looking at the time the person has been employed, what is their average weekly wage? And that is a moving target. What's difficult about that definition is not so much the principle of it, but how to actually apply it. Because I believe it's quarterly that that the average weekly wage in the Commonwealth is determined by the VEC. And so it changes. And actually, it's changed since we finalized these slides. I think it's now actually slightly above $69,000 a year annualized. So because this is a moving target, it makes it a little bit difficult to determine whether you can enter into a non-compete agreement with an employee that is, you know, hovering around that threshold. Because presumably, and the statute doesn't address this, if they happen to be above the threshold when the agreement is entered, and then at some point in the future, as the median changes and perhaps their salary does not, they fall below it, then they might suddenly be a low wage employee, and their agreement may now be violative of the statute. So that's one compliance issue. And then the other is that while the definition of low wage employee excludes employees that are predominantly paid by commission, to try to capture salespersons and those folks that are likely to have the most interaction with customers and business information of the type that you would want to protect with a non-compete agreement, it doesn't define what predominantly means. So again, we can look at what we understand that to mean colloquially, and if someone's actual earnings over the course of their employment, if you break them all down, they are more than 50% commissions, and I think you're probably safe. But, you know, what's the time period for that? What happens if it changes? I mean, if someone's commissions are expected to make up more than half of their income, but it's a really bad sales year, all of a sudden is your non-compete void and unlawful? I don't think that's the intention. It's just not addressed in the statute. We can go to the next slide. Another major ambiguity is what the law says as to customer non-solicits. So the non-compete agreement expressly excludes non-disclosure agreements. So the statute does not apply to restrictions against using or disclosing an employer's confidential information or trade secrets. But just like the federal proposed rule, it doesn't address whether and to what degree non-solicitation covenants are allowable or not, and to the extent they fall under the definition of non-compete. We can go on to the next slide. So, and this is where I think at least the intent was to address customer non-solicits, although perhaps not executed as well as it could be. The Virginia statute provides that a covenant not to compete shall not restrict an employee from providing a service to a customer or client of the employer if the employee does not initiate contact with or solicit the customer or client. It seems like that should make sense, but if you start picking at it, it really doesn't. And that's because a covenant not to compete is entirely unlawful under this statute. The whole point of the statute is that if you are a low-wage employee, which is the only category of individual protected by the statute, then you cannot have a covenant not to compete. So why there would then be a a clarification that a covenant not to compete can't have customer non-solicitation language in it is really unclear to me. Not really sure how to make sense of it. You end up with kind of a circular analysis if you spend too long with it. I think the best interpretation, and what I think the intent of the legislature was that a low-wage employee could have a customer non-solicit, a true customer non-solicit, meaning you're not allowed to go out and solicit, to initiate contact, to go try to get my customers and take their business away from me. But you can't have a customer non-service, meaning you can't prohibit an employee from doing business with a customer if they weren't the one that initiated that contact, if they weren't the one that went after the customer in the first place. So if the customer follows the employee is free to do competitive business with that customer. I think that's the intent. That's how we've interpreted it. That's how we draft our agreements. And we include carve-out language in customer non-solicits that says it doesn't prohibit doing business with a customer if the employee didn't initiate contact. That opens a whole nother can of worms, because how do you prove? I mean, it's a huge loophole for employees. It's easy to get around. How you would prove who initiated contact becomes really difficult. So it renders the veracity of a customer non-solicit with a low-wage employee pretty limited. But at least there's still some option to include that. I think under the agreement, although it's unclear, some option to include that sort of restriction. We can go to the next slide. And what's the harm if there is a unlawful non-compete agreement in Virginia? The big change is that this statute created not only a private right of action for an employee to seek relief from an unlawful non-compete, but also for the Commissioner of Dole to go after employers for unlawful agreements. An employee who brings a private right of action has a 2-year statute of limitations. They could go for injunctive relief, which is not surprising. I mean, relief from an employer trying to enforce the restriction against them. But probably the scarier part is damages. For example, if they can show that they weren't able to work for a period of time and they lost wages, then they could try to recover those from an employer. And of course, they can also get their attorney's fees if they're successful. If the commissioner pursues an action against an employer, they've got the right to seek statutory penalties. Employers are also required to post this notice. I'm not sure how much that's actually happening, but it should be posted along with all of the other required federal posters and notices. And of course, employers are not allowed to retaliate against employees who, raise their rights under this agreement or oppose any sort of attempt to enter a non-compete agreement. I will say I have yet to see, I thought by now when we were initially creating this presentation that by late 2023, we would see some sort of case law interpreting the statute that might clear up some of the ambiguities, at least as to published opinions, which I know there are few in Virginia anyway. Haven't seen it. I'm not sure why that is. My best guess is that the attorney's fees provision is probably resulting in employers not pushing this too hard. If they try to go after someone for a non-compete and this issue is raised, my guess is most employers are just dropping that rather than get into some sort of battle under what this statute means and risk owing the employee and owing their attorney's fees. But I'm not sure. We just haven't seen a lot of interpretation. You can go to the next slide. And with that, I'm going to turn it over to Micah to lead us in the next section of the presentation.
Thanks, Amanda. So, hey, everyone. Again, this is Micah. We are at about the halfway point, and I will take the reins back for the second half of the presentation. We're moving now, again, to later in the employment relationship and really the end of the employment relationship with what I'm referring to here is severance agreements. You may also call these separation agreements. Before we move on, I want to define a couple terms here. So by severance agreements, I mean agreements that we enter into with employees as they're leaving the employment relationship, and we are giving them certain things, in most cases, a severance payment. And in exchange, we are asking for other things to try to make the exit go more smoothly. And the key point usually is the release, right? The release of claims. You promise that you even if you have a claim against us, you're not going to sue us. What I want to focus on today are two terms that are imperiled because of a recent NLRB decision, and those are not the release terms, but instead confidentiality and non-disparagement. And again, before we move to the next slide, let me define these terms so that everyone knows what we're talking about. By confidentiality, I'm not referring to trade secret terms or what I'll call company confidentiality terms, meaning agreements that employees won't disclose the company's proprietary information. Those are fine. Instead, what I'm referring to here are what I'll refer to as agreement confidentiality terms, meaning the employee's agreement that they're not going to talk about the existence of the agreement or the terms that are in it. And most importantly here is the severance amount. And this concept would apply to settlement agreements too. We're usually concerned with discussions that employees have about what they're getting, both in severance agreements and again, also in their settlement agreements if they've actually raised a claim. And then the second term we're going to be talking about is non-disparagement terms. And by this, I mean terms that we often put into these agreements in which the employee agrees to not badmouth the employee. Again, we think we are giving the employee some money on their way out the door. We should get certain things in return. One of those things is that the employee shouldn't speak badly of us. And the reason we're talking about this today, if we can go to the next slide, is because there's a recent NLRB decision that imperils both of these kinds of terms. That decision is called McLaren-McComb. It was issued by the National Labor Relations Board in February of this year. And it invalidated a non-disparagement term and a confidentiality term that was at issue in that case. To understand why, I think we first need to kind of establish some foundation with regard to the National Labor Relations Act. So let's do some more term definition. We can go to the next slide. Let me explain, again, lay like a foundation here, which I think will help us understand the McLaren-McComb decision a little bit better. So if you know anything about the National Labor Relations Act, if you've interacted with any of its terms, it is probably these two terms, Section 7 and Section 8. Section 7 establishes employee rights, and Section 8 protects those rights. The second one is maybe seems kind of like it's shouldn't be necessary, but there's actually a statement in the law that explains what happens if the rights are infringed upon. I'll get there in a moment. So let me start by reading what this section says, and then I'll pinpoint a couple words in here. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. So as you can see, I've bolded the end. We're going to focus on the end here. The beginning, I think, is familiar. It's saying employees have a right to join unions. And then the second section, I think, is also familiar and self-explanatory. Once they are in those unions, they can bargain collectively. In other words, they can join forces to improve their negotiating power. The more ambiguous and less familiar language is what comes here at the end. They have a right to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. So one criticism of the National Labor Relations Act is that it's just very old and that it doesn't apply to the modern economy very well. And as part of that, I would say it has this other issue, which is it just uses old language. It's a 1935 statute, so it's almost 100 years old. This term, other concerted activities, I don't think I've seen the term concerted used in any other context. It means, I think, in concert, to do things in concert with other employees, basically to do group activities. It's a very broad concept, right? It basically, the statute is saying the employees have a right to do things in groups with employees. That is a net that can collect a lot, as we're going to see in a minute. And it's made even broader by this language at the end. What can they do in group activities? Things to protect themselves or to aid in their protection. So again, there's a lot that can be considered concerted activity for mutual aid or protection. I'm going to be giving some examples soon. And then this last section, section 8, is the protection of all of these rights. It says it shall be an unfair labor practice for an employer to interfere with, restrain, or coerce employees in the exercise of the rights guaranteed in section 7. So in other words, if the employer interferes at all with this concerted activity, then they've committed an unfair labor practice. All right, we can move to the next slide. So that was the foundation I wanted to lay to get into the McLaren-McComb decision. As I said in the previous slide, concerted activity is a very broad term, and it has been used by the NLRB, especially in recent years, especially I should say during Democratic administrations, to bolster labor rights and to collect a large swath of employee activity that we probably don't think of as union activity. A good example of this is social media posts. And one thing that the NLRB has done recently, and this I think is sensible, is again to attempt to modernize the act and bring it into the modern economy. And it was designed when there was no internet, right? And if employees wanted to picket or protest their employer, they had to literally do that. They had to go outside and picket or protest in front of the workplace. Now they have social media available to them. They have other places, they have other megaphones for making their complaints. And the NLRB recently has attempted to use the language to allow for that kind of activity to be included as well. So there's a lot of cases about employees saying things on social media in recent years. The other thing I wanted to note here is a lot of employers, I think, tune this part out because they don't have a unionized workplace. And I'm in Virginia, and so something I hear often from employers here is we don't really have a union culture in Virginia. My workplace isn't unionized. I'm not worried about it being unionized. That's a fair response. But note that these rules that we're talking about don't just apply to the unionized workplace. They apply to any workplace that could become unionized, which means virtually any workplace. So in other words, your workplace is probably subject to the National Labor Relations Act, even if you don't really think about it very much. Okay, we can move to the next slide. All right, so now we are at the McLaren-McComb decision, again, the one from February of this past year. What the NLRB said here was that an employer violates the NLRA if it offers a severance agreement that includes these terms, the kinds we've been talking about: confidentiality of the agreement and non-disparagement of the employer. The inclusion of those kinds of terms are per se violations of the NLRA. Why? Because of the other concept we've been talking about, because they interfere with employees' concerted activity for mutual aid. Okay, how do they do that? If we could turn to the next slide. The McLaren-McComb decision focuses on the different audiences for employee speech. Again, because we're no longer talking about just employees picketing out in front of the workplace, we're focused on other places where they can speak about their employees and about their employers. And again, I think a lot of this is about what people want to say online. And what the NLRB has said in this case is that non-disparagement terms, we'll start with non-disparagement terms, are violations of the NLRA because of the different audiences that now aren't going to be able to hear about the employer's employment practices because of these terms. In other words, an employee who might otherwise badmouth an employer can't do so anymore, and that's going to imperil other employees' ability to unionize or collectively bargain. So the NLRB focuses on these three audiences. The first one is the public, and this is almost a direct quote from the case. Employee statements to the public about an employer are a core NLRA right. That's kind of a circular point, but basically I think what they're saying is it's important for employees to be able to talk about the terms and conditions of their employment outside of the workplace, and they're not going to be able to do so if they think that they're not allowed to say anything about the employer because they entered into a non-disparagement term as part of exiting the employer. The other audience that the NLRB is focused on is other employees. Now, keep in mind here, this is what's interesting about this, I think, is that we're talking about somebody who isn't an employee anymore, right? They've signed a severance agreement. They're not even an employee anymore. And so I think a lot of employers would think, well, we're not worried about their concerted activities, right? They're not even employees anymore. But the NLRB has said, no, we are still concerned with those employees' ability to go back and talk with their former coworkers, the other employees of the company. And if a former employee can't speak ill of an employer, then she can't discuss the working terms and conditions with the current employees. So we're going to basically, again, we're going to have less concerted activity because everybody feels like they can't talk about the employer after they leave. And then finally, the NLRB focuses on the ability of employees to go to talk to them. And they're worried about complaints, but I think just as much they're worried about other employees making complaints, current employees making complaints, and the NLRB trying to learn about the employer by going to talk with a former employee, and the former employee can't talk because they've entered into a non-disparagement term. If we can go to the next slide, the analysis here is very similar when it comes to confidentiality terms. The NLRB says, again, we're focused on the ability of former employees to talk with their former coworkers and their ability to come bring complaints to us. I think it's maybe useful to have an example here. So let's think of a circumstance in which a current employee complains about meal breaks or rest breaks, that doesn't think that the employer is providing sufficient breaks. And that things go awry, the employee leaves, the employer pays that person a severance agreement or a severance payment. Their concern is that now that employee feels like they can't come back and talk with other employees about the same issue that those employees are facing. And as a result, the current employees can't fight for the longer meal breaks that they're entitled to. And then again, as I mentioned a minute ago, they're also concerned that confidentiality terms are preventing employees from coming and bringing complaints to the NLRB or being a part of investigations. If we can turn to the next slide. So this is now NLRB law. I'm gonna start moving through some of these slides quickly in the interest of time. So this is different than what Amanda was talking about before, which was proposed rules, right? And we're waiting for final rules. This is now NLRB law. This is case law, and the case is the breadth of the case is very strong here. The risk is not just that an employer would attempt to enforce one of these terms, because you might be thinking, why don't we just get the deterrence value of these terms? Let's put them in the agreements. Maybe we won't enforce them later. The NLRB has said, no, that's inadequate. Just offering these terms in a severance agreement is an unfair labor practice. And we can turn to the next slide. There's a couple saving graces here, and they are provided by the general counsel who issued an opinion not long after the McLaren-McComb decision. And this is what the general counsel said. First of all, this is the general counsel of the NLRB. You can still have non-defamation terms, meaning you can't just say that an employee isn't allowed to disparage the employer. You can say that the employee can't defame the employer. I don't find that one all that useful because we already have defamation law, right? Defamation law is already there's already liability if somebody defames us. So we don't need to determine our severance agreements to get that. But the second point is a fair one. The general counsel said, well, you can't limit employees from talking about every term in their severance agreement, but you can limit them from talking about the amount of their severance. And that's probably the thing that we're most concerned about. So I do think that is a saving grace. If we can go to the next slide. A few other saving graces. This case doesn't apply to supervisors because the NLRA doesn't apply to supervisors. And supervisors is defined fairly broadly as anybody who exercises independent judgment. So we can still use these kind of terms when supervisors leave the company. And then finally, the thing I started with at the beginning, we're not talking about trade secrets here or other proprietary information. We can still prevent employees from talking about those things. We're just talking about the terms of the settlement agreement themselves. Okay, next slide, please. All right, a few tips for how to draft agreements in a way that isn't going to run, or at least is less likely to run afoul of the NLRB rule. State expressly that employees are allowed to bring their claims to the NLRB. We already draft these into our agreements. Some people call these savings clauses. We might be trying to keep you from bad-mouthing the company, but we're not trying to keep you from going to speak to the NLRB or another agency. We should just say that expressly. Number 3 here, some employers might not like this, but I do think it would help if we had an expiration date on these things. Basically, if we said, as Amanda mentioned earlier, it's when the employee leaves the company, it's that first year that's really sensitive. Maybe we can keep them from bad-mouthing us in that first year. And then, we're less concerned about what comes after. Their ability to impact us is less of an issue. And I think the NLRB would look more favorably on a confidentiality or non-disparagement term that had a shelf life to it. Okay, if we can go to the next slide. All right, this is more food for thought. Is maybe we should consider whether it's worth abandoning these terms altogether. Maybe they're not getting us much. Often when an employee leaves, when we enter into one of these agreements, the relationship is fraught and employers are pretty hot to get a non-disparagement term. It feels right? Like we've just gone through this difficult thing with this employee. Like at the very least, what we should be getting is a guarantee that this employee is not going to speak ill of us. That is an understandable sentiment. But I think if we look back on these things, it's fairly rare that we're ever actually attempting to enforce them. And in part that's because it's hard for us to know if the employee is ever actually disparaging us or talking about their confidentiality terms. So I wonder if these terms are basically worth their cost. Presumably part of the severance payment is going to pay for these terms, right? We need consideration to be able to make them enforceable. If we're not going to enforce them later anyway, maybe they're not worth the trouble. That's again, maybe something to think about later on today. Okay, we're going to go to the next slide, please. And it's at this point, we have another polling question. So if we could put the poll, okay. Thank you. So this is a true or false. True or false. The National Labor Relations Board has concluded that severance agreements are unlawful if they prohibit former employees from speaking freely about the terms and conditions of their employment. True or false, we'll give you 30 more seconds to enter an answer. Okay, please put in an answer if you haven't already. We're going to be moving off of this poll in just a moment. All right, and here are the answers of the poll. 71% true, 29% false. I would say true is the right answer. The thing we do know is that we can't, well, I just say this, we have to be very careful about trying to prevent employees from speaking with others about the terms and conditions of their employment. I think if there was one takeaway here, I would say anytime we're trying to prohibit what employees can say, some government agency is going to look dimly on it. So we have to be careful with that. We have 5 minutes left. I think we'll be able to take a question or two at the end. We just wanted to cover two miscellaneous topics here at the end because we get clients asking questions about them often. The first is sex harassment claims and terms that prohibit employees from talking about their sex harassment allegations in particular, because there have been new statutes growing out of the Me Too movement that apply to these kinds of confidentiality terms in particular. So it is true that we can't impose pre-dispute confidentiality terms on employees. That says release. It should probably say confidentiality. So this is what people often refer to as non-disclosure agreements, meaning before the employment relationship even begins, we are going to restrain you. And no matter what happens to you while you're an employee with us, you're not going to talk about it, including if you're sexually harassed. Those kinds of agreements are now prohibited by federal and state law. On the other hand, what I'll call post-dispute confidentiality terms, meaning terms at the end of the employment relationship in severance agreements, in other words, what we've been talking about, or even settlement agreements, which prohibit employees from talking about their allegations, those are still okay in Virginia. Some states have prohibited those as well. Virginia still allows for these kinds of post-dispute confidentiality terms. But keep in mind, we've just been talking about how the NLRB is looking dimly on any of these kinds of terms that prohibit employees from being able to talk about their work experiences. So we might see issues with these terms with the NLRB as well. And then finally, if you could turn to the next slide, this is a question that we don't get very often, but thought it was worth pointing out to employers. This is the dog that doesn't bark. This is the thing that's in your severance agreements, but you might not even appreciate it, which is that we have to tell employees that despite what's in the agreement, they are free to go to a government agency and complain about us. We don't have a lot of wiggle room with these. The statutes that establish these agencies and make employment discrimination laws or workplace safety laws are explicit that employees have to be able to come and bring their complaints to the agencies, and we can't stop them from doing so. So you might say, well, that's a pretty big boulder if we are trying to enter into a severance agreement. Isn't the whole point that we're trying to prevent these employees from bringing their complaints to an agency? Well, somebody, and it isn't me, somebody back in the day has come up with a clever workaround, which is, well, we will allow you employees to bring your claims to these agencies because we can't stop you from doing that. But we can prohibit you from getting any financial benefit from doing so. And the theory here is if you can't get any remedy, if you can't get any money basically from your claim, then you're not going to be incentivized to bring your claim to an agency. But we have to note that this is just kind of a theory, right? Or it's an incentive. It is unfortunately true that we could pay an employee a severance term, a severance payment, and they could still go to the EEOC after and complain about us. Most likely, the EEOC isn't going to take an interest in that charge if we can show that we have already settled with the employee, because they've got more charges than they know what to do with. And if this particular employee has gotten paid by an employer, then they're probably going to move on to the next one. But we have to accept that it is possible that the EEOC would actually take one of these charges and investigate a charge with an employee that we already gave a severance payment to. All right, so that's the end. Amanda, were there any questions? You've been looking maybe at the questions. Did you see anything that was worth us trying to answer in this last minute or two?
We did. We've gotten quite a few questions, so thank you everyone for your participation. We obviously don't have much time to respond, but if it's okay with you, Micah, there's a thoughtful question on the non-compete issue that I think we can answer pretty quickly.
Yeah.
And so we got the question: are your clients proactively eliminating their use of non-competes in advance of the final rule, even if it's likely to be challenged, or are they waiting? And I would say, with regard to the final rule itself, I'm not seeing clients make a change in terms of their non-competes. There's no harm in having one now, as long as it complies with applicable state law and it's not violating a state law. Having a non-compete now is still allowed at the federal level. And so I'm not seeing this decision change, have an immediate impact on whether employers are entering non-competes. That being said, I have been counseling employers to be thoughtful about whether they need a non-compete for many years. And that's because non-competes are, sort of to Micah's point about the non-disparagement and confidentiality clauses, if we stop and think, do we really need this? In most cases, again, when we exclude the founder of the company, the inventor of the secret sauce, the 20-year CEO, when we exclude those sorts of employees, most employees don't need a non-compete. And for most employees, it's likely enough to have a protection against them soliciting your customers, a protection against them taking your employees, a protection against them taking your trade secrets. And frankly, if an employee has done nothing but go compete, and they are not in fact taking any customers, and they're not taking any trade secrets, and they're not taking any employees, ultimately you're going to have a hard time winning on a non-compete case, because you're going to have a hard time proving that you've been damaged in any way. And so in that regard, I think it's worth it, if you're not already, to use this sort of shift in the public policy and potentially the law to reassess whether and how often you're using non-competes. But for now, they're still on the table, and I'm still seeing employers use them.
Okay, thanks, Amanda. We are, I think, in our final minute. Do you want to take us out as we transition to break time?
Sure. Yeah. Thanks everyone for your time and all of your questions and participation. We're heading into break now. After the break, you're going to hear from Janet Cho, who will discuss risks and recommendations for AI generated content at 11:30. Thanks, everyone.
Thanks, everyone.